Yes.
I'd be interested in your observations regarding the use of force under color of state law in a 1983 type action in comparison to self-defense, and perhaps a further comparison to the international use of force by a state.
I'm sorry, could you remind me about type patch?
The 1983 type actions under color of state law, police officer using excessive force shoots and kills an individual. 1983 gives the officer...
Oh, you mean the section?
Section
not the year.
1983.
Okay.
I apologize.
No, I understand. Okay, so that's interesting, actually. These 1983 actions are based upon the idea that the excessive use of force can violate the due process rights of the victim, and that therefore you can bring a civil rights action for violation of your rights as a victim. And this is a good way to introduce the requirement of proportionality, so that the police officer is not entitled to shoot just because it's necessary. Here, I think there was the Grover case, or Grover, or something like that. In that case, the officer could say it was absolutely necessary, but it was disproportionate relative to the threat that the escaping kid represented. So he could claim this was disproportionate force, and therefore it violated my rights under the Due Process Clause. And I think that's, if you take, the interesting question is whether you could apply this and how you would apply it in international law. I think we haven't seen an action like this, but it would be very interesting to develop a civil action based upon having suffered excessive use of force, and you, after the hostilities were over, you could bring possibly an Alien Tort Claims Act for violation of the laws of war, if you could get jurisdiction in the United States and so forth. That's a good question.
When you discussed the analogy between the domestic criminal law with respect to self-defense and international criminal law's understanding of self-defense, you've referred to what you call the domestic analogy, call the whole construct the domestic analogy. It seems to me that one area in which the domestic analogy may well break down is in the inability, unwillingness, or inapplicability in the international law arena to account for, say, diminished capacity, or to account for behavior that's highly emotional, behavior that we might condescend to, that we might excuse. But perhaps in the post 9/11 environment, the best way to understand the behavior of the Bush administration might be through the lens of diminished capacity, a highly emotive state that completely clouded the analytic faculties.
No, I think it's a good question. Actually, the general point is, are there excuses in international law? There are definitely. Most of international law is based upon principles of justification. And the one justification that is recognized in the UN Charter is Article 51, and you have to work with that. But sometimes people argue necessity as a justification for intervention to prevent victims of the tsunami or something like that. I think it's better to, well, it's an argument in the field. Necessity is a justification. But Merkel's question is, can we recognize excuses? And here, I think one of the concrete questions that really does come up is how you treat mistakes. So, my God, we made a mistake. They didn't really have the weapons of mass destruction. We thought so, and we might even say it was a reasonable mistake. Now, what kind of an argument is that? We made a mistake. I mean, our intelligence told us. That's what they told us, so I'm sorry, we made a mistake. Can you say that in the international arena? Now, that depends on how you treat the theory of mistake. And there are people who claim that a reasonable mistake is in fact a kind of justification. It makes the conduct right. I don't believe that. This, by the way, this is the position of the Model Penal Code. A reasonable mistake is a justification. Therefore, you're reasonably mistaken about the attack. You have what's called, the Europeans would call it putative self-defense. But you have real self-defense, according to the American view. The Europeans would say, and I think I agree with them, no, no, the mistake is an excuse, and now I don't think we recognize excuses in international law. That is, an aggressor cannot say, I was insane. I was suffering from diminished capacity. It has nothing to do with jus ad bellum. That is, the defender is entitled to defend himself. The defendant, the party that is occupied still has a claim for damages that might have existed otherwise. So the excuses don't apply at the international level. That's my argument.